Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. We are going to spend our 15 minutes talking about some new time off protections for qualified employees. As many of you probably know, the California legislature was very active this year. We had a number of new laws that came into play, and one of them has caused quite a bit of consternation for folks. In fact, we just had a webinar earlier this month for a bunch of employers who were really confused about this whole time off for crime victims, and that the new law also affects the use of California mandatory sick leave. So I wanted to take some time today to deal with some of the issues that came up during the webinar and make sure that you all understand exactly what's going on here. Okay, the first thing I want you to understand about this time off for what we call crime victims is that it's been in play for a while. And before the new law, we had a number of labor code provisions that gave employees the right to take time off or protected them against retaliation for taking time off relating to being victims of a crime. There was Labor Code Section 230 and Labor Code Section 230.1. 230.1 applied to employers with 25 or more employees. Now, Assembly Bill 2499, which took effect on January 1, 2025, replaced Labor Code Section 230 and 230.1 and amended Labor Code Section 246.5, which is the mandatory paid sick leave. Now, a lot of the current rules carried over, but there are some new things that you need to be aware of. The first thing is these provisions that were in Labor Code Section 230 and 230.1 for victims of crime, those have moved to the California Government Code under the Fair Employment and Housing Act, and they're going to be enforceable by the Civil Rights Department. Remember, they used to be called the Department of Fair Employment and Housing, rather than the Division of Labor Standards Enforcement, the DLSE, which is essentially our labor commissioner. Okay, so that's important to understand. They're no longer under the Labor Code and under the jurisdiction of the Labor Commissioner. They're being moved to the Civil Rights Department, and they're protected under the Fair Employment and Housing Act, which is in the California Government Code. The other thing they did is they have changed the format of the protections to look like other laws that we have on the books regarding leaves and accommodations, including the California Family Rights Act. Okay? So the first big change is those two labor code provisions don't exist anymore. They're now moving to the government code, and we've got this new enforcement entity, the Civil Rights Department. Now, that matters if you put in your employee handbook, for example, Labor Code Section 230 or Labor Code Section 230.1, you're going to have to take that out. This is why we don't ever recommend that you do that in handbooks. You just describe what's going on, and you don't actually list a code section because they can change, and that's what happened here. Now, something new in the law is this term qualifying act of violence, okay? The law before January 1, 2025 required employers to provide time off for victims of crime or abuse in some of the provisions, and for victims of domestic violence, sexual assault, or stalking in other provisions, okay? Assembly Bill 2499 replaces that terminology with the phrase qualifying act of violence, which includes domestic violence, sexual assault, stalking, and any act, conduct, or pattern of conduct that includes bodily injury or death to another, brandishing, exhibiting, or drawing a firearm or other dangerous weapon, or a perceived or actual threat to use force against another individual to cause physical injury or death, okay? Importantly, the qualifying act of violence will entitle employee to certain rights, whether or not anyone is arrested for, prosecuted for, or convicted of committing any crime. So it's not a precursor to the protection that the individual be prosecuted or be found guilty, all right? Now, under the new law, all employers of any size, it doesn't matter how many employees you have, are prohibited from retaliating against or otherwise discriminating against any employees who participate in the legal process. So they're a witness, they're a party to an action, anything like that. So let's say they want to take time off to serve on a jury trial, okay? Or they have to comply with a subpoena, or they're going to obtain a restraining order, okay? Now, the first thing, being on a jury trial, remember, that has nothing to do with domestic violence, right? That's just a protection that all employees have. But when we talk about these qualifying acts of violence, they may have to appear in court to comply with a subpoena or another court order, or they may want to get a restraining order, okay? And you cannot discriminate against or retaliate against an employee because they are a victim of a qualifying act of violence or because their family member is a victim of a qualifying act of violence. All right. Now, some of the protections of AB 2499 extend to the family members of employees. Okay. And this is important because a family member is defined as a child, parent, grandparent, child, grandchild, sibling, spouse, or domestic partner, as those terms are used under the California Family Rights Act, or also as used in the California Family Rights Act, a designated person. Remember, employees can designate a person once every 12 months. They do not have to be a blood relative, but the association with the employee needs to be the equivalent of a familial relationship. All right. So if you have 25 or more employees, you're also going to have to comply with the anti-discrimination, anti-retaliation, reasonable accommodation, and paid sick leave, allowing people to use paid sick leave if they have a qualifying act of violence or a family member has a qualifying act of violence. All right. Now, if you have 25 or more employees, you also cannot discriminate against or retaliate against an employee because the employee or a family member has to take time off to obtain or attempt to obtain relief, as we said, like a restraining order or some other form of court relief. They're going to get medical attention because they've been injured. They're seeking services from a domestic violence shelter or a similar organization. They're getting counseling, mental health counseling. They're participating in safety planning, or they are relocating. Okay. And that includes moving to temporary or permanent housing or enrolling children in a new school. Also providing care to a family member who's been injured, going to court to seek civil or criminal legal services, participating in any civil or criminal or administrative proceeding, or finding childcare, either for a minor or care for a care-dependent adult, okay? Some of these purposes were already covered under the current law from prior to January 1, but many of them were added by AB 2499. Now, AB 2499 permits you as an employer to limit the total amount of leave time that an employee takes, all right? And it depends on whether the employee is the victim of the qualifying act of violence, in which case they get 12 weeks, or the family member is the victim of the qualifying act of violence, in which case they get 5 days for relocation purposes and 10 days total. Now, this is just a weird quirk. If the victim passes away as a result of the qualifying act of violence, you actually get the full 12 weeks, even though it's for a family member. So it's 5 days for relocation, 10 days total. Now, AB 2499 made clear that this leave runs concurrent with the CFRA leave and the FMLA leave. Okay? So that was unclear before, whether you could run it concurrently. You certainly can. You can require certification from employees. That's fine. So if somebody wants a reasonable accommodation, let's say to implement some safety measures, they want to be moved to an office that's behind a security perimeter. For example, you have to engage in the interactive process with them. You can only refuse to provide the accommodation if it's not effective or it would impose an undue hardship. If the employee refuses to disclose the name or their family member status to them as a qualifying as a victim of a qualifying act of violence, you don't have to provide the accommodation. They have to provide that information. And you can also require some sort of certification to show, like it could be a police report or a court order, documentation from domestic violence counsel or a victim advocate, something like that. And you do have to allow the employee to self-document, right? So they can give you a written statement that explains the basis for their need for leave. There is also a new notice requirement. By July 1 of 2025, the Civil Rights Department is going to publish a form notice that you have to post. It has to be posted no later than July 1, 2025. And once they publish the notice, you have to provide employees notice under the law. You don't technically have to use the form provided by the CRD, but you should. Because you want to make sure that you don't open yourselves up to an argument that you didn't fully comply. Okay, so there is a lot here in AB 2499. I know it's confusing, and I know that you really have to think through, okay, am I an employer of 25 or more employees? Because if I am, I have more requirements. But even small employers have an obligation under this law. So you have to be very careful that you're updating your employee handbooks. Remember, they're allowed to use this paid sick leave if they have 25 or more employees for the purposes of caring for those family members. So it doesn't expand the amount of time they get for paid sick leave, but the uses that may apply. Okay, so you're going to have to change your policies and practices. You've got to make sure that anyone in human resources responsible for enforcing the policy understands the rules, knows what's going on. California is not the only state that has protections for victims of violence and their family members. So again, if you are one of those employers who has multi-state operations, you're going to have to look at the laws in your other jurisdictions to make sure that you know what's going on there. We do a lot of multi-state work for clients, so it's very common for us to do charts and surveys of particular issues. That's just the only way you can make sure that you're on top of what you need to be doing from an employment perspective. The other thing to understand here is that there is abuse of these laws, okay? There are people, just like when the new bereavement leave law came into play last year, and all of a sudden somebody's relative passed away 4 times in the year. How could the same relative pass away 4 times in the year? They can't. So there is abuse, but you cannot start with the presumption that there's abuse. If you do, you're going to end up denying leave to somebody who's entitled to it. And that's going to create some legal issues for you. So it's very important for you to train your leaders to let you know when an employee has raised their desire to take time off under any of these laws. They're explaining that the supervisor manager is explaining that the employee should go to HR, go to personnel, that they need to get information from those folks so that they can ensure that they're taking the time appropriately, that they're getting what they're entitled to. Remember, when that notice comes out, you're going to have to post it. You should probably send it around to all of your employees so they know that it's a new protection. It will be in the all-in-one posters that you can buy from various entities once it becomes effective after July 1. But until then, you're going to have to make sure that your employees have notice. And some of these all-in-one poster companies don't get it done for a few months. So as of July 1, you're going to have to make sure that they understand what the requirements are. So a lot to do here. There, of course, every year is a long list of things that California employers need to stay on top of, but it's not just California. There's a lot going on all over the world right now in terms of workplace rules, workplace laws, workplace regulations. So you really have to stay on top of things. Remember, if you have ideas for the podcast, you have ideas for guests or topics you want us to talk about, please, you can email me anytime at jshaw@shawlawgroup.com. I want this to be a podcast that really helps all of you and that you find to be a valuable resource. So please, if you're not finding that, let me know. And if you are, it'd be good to know that too. Everyone, thank you so much for joining me today. It is such an honor that you're willing to spend these 15 minutes a week with me. Thank you. Again, keep up the fabulous work. I know your job isn't easy. You do it because you're passionate about it, and that does make it a little bit easier. But give yourself a break. We're early in the year. You've got a lot to do. Just take it one step at a time. That's the only thing you can do. Thanks so much, everyone. I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others. Post about it on social media and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.